All right, good morning, everyone. Let's get started with our civil docket for February 23rd, 2022. We're now live on YouTube. I will take announcements from any attorney who's ready to make an announcement. If you can give me a reaction button, raising your hand, giving me a reaction button, letting me know that you're ready to make an announcement. I will take your announcement at this time. All right. You don't look like Savannah, though.
No, it's not, Judge. It's I'm Christopher Castillo standing in for Savannah on cause number F 3814-219. I believe it's set for status this morning.
F 3814.
I'm sorry. It's CL 3628H. I'm sorry. I apologize.
Okay, no problem. CL 203296. You said correct?
3628.
3628. Yes. In the interest of Hector Santiago Guerra, deceased, Chris, yes. And is Judge Contreras on, I think he's on the other side. I don't see him on right now, Mr. Castillo. Do you mind hanging tight? This is just a status conference. I think we were going to get some dates, and I think that you all were going to attempt to mediate or get together and see if something can get resolved with Judge Contreras' office. You're on mute.
I'm sorry about that. That's fine. I'll wait around until he logs on.
Perfect. Thank you.
Thank you. Up here.
All right. Anyone else ready to make an announcement? Mr. Youngs, I think you're here with on a case with Mr. Gray. That's CL 214283H. Feliciano Chen versus Connie Cobb, substitute trustee.
Yes, good morning, Judge. We just filed our notice of appearance this morning for Mr. Chen. I tried getting in contact with Mr. Gray this morning, but I understand he had hearings. I wasn't sure if it was possible for us to maybe go into a breakout room just to try and discuss, because at the last hearing, I believe, I read the transcript and the parties were going to try and reach a final negotiation for a property dispute. So I was hoping maybe I can speak with Mr. Gray about that before proceeding in the status conference.
Perfect. I think that's a great idea. Let me put you in a breakout room. I'm going to open up the room, accept the invitation, then come right back when you guys are done.
Thank you, Judge.
You're welcome. All right. I have an Art Smith. Can you identify yourself, sir, or ma'am? Art Smith? Raising their hand. They're on.
Judge.
I'm sorry?
Judge, I'm sorry. I didn't realize I was muted. I'm here on the Mary Alice Arcos versus La Plaza case. I'm representing a party that's not a party to the summary judgment motion. I'm just monitoring that proceeding as it pertains to the two parties who are the
Okay. So no problem. So then I have Mr. Garza and Mr. Chapa, then I suspect, for the summary judgment. Is that correct?
That is correct.
Right.
I don't know if the court wants us to wait or if the court wants to take it up now.
Well, I'd like to take up quick announcements, but no one else is raising their hand. So therefore, I guess they want to wait and we can go ahead and hear the summary judgment.
Very well, Judge. May I proceed, Your Honor?
Sure, go ahead.
Well, I guess as the court's well aware, I haven't been practicing too long, but if I've learned one thing is if it takes you longer than 5 minutes to explain your summary judgment, you're probably not entitled to it. So I'm going to be really brief here, Judge. In plaintiff's petition, they basically allege essentially a single cause of action for premises liability under the theory that plaintiff is an invitee. Our no evidence summary judgment, as the court's aware, we just need to disprove one of their elements of their cause. So what we're really going after here, Judge, is the fact that the plaintiff is not an invitee. They cannot prove that they're an invitee, and we've actually produced evidence in support of our summary judgment motion that says they're not an invitee. And I've gone through the law on our motion, Judge. It's very clear that when a person is going through a place of business and they're not going to be providing any sort of mutual benefit, they're not an invitee. I've I've copied some relevant portions of the plaintiff's deposition, Judge, where she basically says, I wasn't going to that store. I was not going to provide them any benefit. I had no intention of being there. I was just taking a shortcut across the store. In addition, one of their interrogatories was, give me any evidence that says you're an invitee. The response was none. There's a corresponding admission right after that interrogatory, which is produced as evidence on our motion, Judge. It says, we are admitting that our answer to our interrogatory is complete, truthful, accurate. There's nothing that needs to be produced in response to this because we have no evidence to show that we're an invitee. The plaintiff could, I guess, contradict that with some form of evidence, whether it be an affidavit, whatever the case might be. No evidence has been produced on the part of plaintiff's response to our motion to contradict our evidence. With that, Judge, I don't think that there's any evidence that the plaintiff can show at this point, or will be able to show, that it'd be directly contradicting their own deposition testimony, their own responsive discovery, any evidence that would show that they're an invitee, Judge. And with that, I believe that we're entitled to summary judgment, Judge.
So, Mr. Chapa, let me get this straight. So I'm assuming La Plaza Mall is who we're talking about here, Assignment Property Group, right? Right, is that correct?
No, Judge, we represent La Plaza Beauty. La Plaza Mall is represented by Mr. Smith. La Plaza Beauty is essentially one of those little kiosks in the mall. And basically what is alleged to have happened is the plaintiff was walking towards a fossil store and allegedly tripped while crossing through our place of business through that little kiosk. Okay,
so like they had maybe they were running electrical wire from one part of the kiosk to the other and she tripped on it or something?
There's a little, they did produce a picture of the kiosk with their motion, Judge. It's a little, I don't know what you call it, I guess like a lip.
Like a riser or something to protect wires that are being running underneath?
No, Judge, it's kind of like a little, just, let's call it a platform. It's a little raised corner.
Okay. And so she tripped on that. And your argument is she wasn't going to stop at that kiosk.
Correct.
And therefore was not an invitee and was basically, just crisscrossing the hallway to go
right
from point A to point B. And therefore you owe no duty.
Correct, Judge. And I've cited a couple of cases in our motion that basically say, if they're not there to give a mutual benefit to both parties, someone's going to get money, someone's going to get a product, then they're not an invitee. At that point, they come down to a licensee or a trespasser, Judge. And those are different duties that are owed, as the court's well aware. But in this specific instance, because they were just taking a shortcut across the business to get to another place, and her deposition testimony says that, she says, I had no intent to visit their store. I was heading for the fossil store. That mutual benefit couldn't have happened. Therefore,
now this is a little different because you could argue that I go into Walmart or I go into Fossil, for example, and I may not buy something, but I'm an invitee by the mere fact that I'm browsing. In this situation, it's a kiosk. So unless you have the intent to stop to purchase something or inquire about something, a watch, jewelry, whatever that may be, then your argument is that they don't have any duty.
That's correct.
To protect the invitee.
Whether you're browsing, potentially going to buy something, if that mutual benefit's not there, you're not an invitee.
But if she was browsing, then that mutual benefit would be there, but she wasn't.
That's correct, Judge. And her deposition testimony says, I had no intent to go to that store. I was heading for the fossil store.
I mean, you can't even call it a store though, right? I mean, it's an area. She had no intent to stop in that area.
Correct. That's correct, Judge.
All right. Let me hear from Mr. Garza. Here's the response.
Good morning, Your Honor.
Good morning.
My argument would be that because it's a kiosk, it is an open area, as you mentioned earlier, And that aisle, and my client was not crossing through their business. If you'll please refer to exhibit number one.
Let me share the screen. Do you happen to have it on your computer that you could maybe share that with?
I'm afraid not, Your Honor. I apologize for that.
Okay, no problem. Let me try to see if I can open it up on my side computer.
Yes, I would appreciate that.
Exhibit 1?
Yes, exhibit 1.
And that's in your response, Mr. Garza?
It is correct, Your Honor.
Exhibit 1 on your response. Give me one second. Okay, yeah, it looks like it's like a raised platform.
Yes. And even worse, it's the very corner protrudes out into the aisle. And my point is, whenever you have a kiosk, those aisles are common areas. They are used not only by La Plaza customers, but also by kiosk customers. And Your Honor will refer to exhibit number 2. I think there's a good example on the picture on the left side that shows an employee, what appears to be an employee and a customer of La Plaza. They're using the aisles. They have to use the aisles. How else are you going to get to the fossil store? You know, I mean, you can't fly over there. You have to go through the aisles. And by them having a kiosk that is on the aisle and going further and actually building a wooden floor raised above the regular floor. And it gets even worse because if you look at the corner on exhibit number 2, the picture on the right, and there's also a picture on exhibit number 1, it shows that it protrudes out into the aisle. So anybody that's using the aisle could very easily trip over that. They're invading the aisle space that is used by invitees of La Plaza Mall. So this is about cutting across.
But the question then is La Plaza Mall responsible for that, or did they add that addition?
A good question, Your Honor. They are named as co-defendants, so I feel that both are responsible. La Plaza Mall since they have control over the aisles, and La Plaza Beauty because, hey, they took it upon themselves to build a flooring that extends out.
La Plaza Beauty built that.
Correct.
As far as, yeah, it's theirs. That is correct.
Okay, so that's going to be obviously La Plaza Mall's argument. They're going to argue, hey, they took it upon themselves to do this. We didn't acquiesce to it, and therefore we shouldn't be held responsible for some action that they did that put all the customers at risk.
Yes, so we have both defendants pointing fingers at each other, at least that's not being responsible.
Correct.
That's correct, Your Honor.
Okay.
And there is a mutual benefit. The mutual benefit is customers that are at La Plaza Mall. They're there, like as mentioned earlier, to browse. Do they necessarily have to browse at his store? Do they have to stop? No. The reason the kiosks are there is they're hoping people happen to pass by and go by. And under Nixon, I have cited Nixon, as we know, as a controlling case since 1982 by the Texas Supreme Court. It says that may benefit. It doesn't have to benefit a business. It may benefit the business. How might it benefit the business? People that are customers at the mall, they are browsing. Hopefully they'll stop in and do business with La Plaza Beauty. So we feel there's certainly a genuine interest to a material fact, and we do ask that the motion for summary judgment be denied.
All right, Mr. Chapa, anything else?
Very, very briefly, Judge. As far as Nixon goes, I've scoured through that case from top to bottom, word searches, everything. I cannot find the word may in that case. I don't believe that is the law. In my motion, Judge, I cite several cases. May is not a controlling issue on here. Is there going to be a mutual benefit or not? And I would just continue to add, Judge, that basically in plaintiff's response, while I kind of understand where Mr. Garza is going with this argument, it's not supported by case law. It's by any evidence. To defeat a no evidence summary judgment motion, they need to produce some evidence of the elements. We are contesting the element of an invitee. They have produced no evidence. So it's a procedural issue at this point, I believe. They've produced no evidence that will say, yes, I'm an invitee, or whether there's a genuine issue of material fact as to whether or not she was an invitee. The evidence has been produced, maybe goes to, maybe there's a dangerous condition at the premises, maybe, but it does not go to whether or not she's an invitee. Her deposition testimony says, I'm not an invitee. The responses to discovery say, I'm not an invitee. And I would leave it at that.
I mean,
Judge, would it be possible for me to offer less than 60 seconds of my own perspective on this as the mall's attorney?
I don't,
Yeah, no, not right
I
now.
would object. Your Honor.
Well, I was going to support your position, so you
Oh.
might want to you might want to take that back.
I leave it to the discretion of the court, of course.
Yeah, no, I mean,
It's all right, Your Honor. I just thought I'd ask because I think it's akin to somebody, even if they're not a premises occupier, if they dropped something like a Coke, in this case, they dropped their kiosk. If you drop something and you create a dangerous condition, you're the creator of something that creates a risk to somebody else. You're responsible for that. The premises liability theory may be the wrong theory if the mall is the premises occupier. But if you create a dangerous condition, like say somebody in your courtroom today put an extension cord across the floor and somebody else tripped on it, they don't have to be the premises occupier. They created something that caused somebody to get hurt. So,
so I guess ultimately it is a dangerous condition. The question ultimately turns on where does the invitee issue come in? I mean,
Right, Judge. I guess to kind of answer the court's question, if the plaintiff were to amend their pleadings and drop invitee and go down to licensee, then I don't know that I can contest that. I don't. There's a lesser duty and there's a little bit more that needs to be proved on the plaintiff's end, but that's not the case that we have. I don't think that they can prove an invitee based on their discovery response to the deposition. Whether she's a licensee, that's a different question, but it's not pled. So that's,
So you're saying that, Mr. Chapa, that you could create that this kiosk could have created a moat in between and put alligators in there. But if somebody falls into it, as long as you're not going to go and shop at this kiosk, that this person is not, the kiosk is not responsible.
Well, Judge, I understand the court's position, but
It's not a position, I'm just trying to understand it. I'm just trying to understand like where are, I mean, look, if it was a flat surface and somebody just tripped over, something that is reasonable, but I'm looking at this picture and it's like, okay, so who created this little ramp? And I'm assuming they created it in an effort to try to attract attention, attract business. I'm assuming they did it to try to improve the facade of the kiosk, and in doing so, they created a lift that, I mean, is it even ADA compliant? I mean, I'm looking at it as like, man, from what I've learned recently, it's 2 inches for every foot. Is it even ADA compliant? So at what point does, I mean, I guess at that point, I can understand your argument. And Mr. Garza, obviously repleading under a licensee, is not something that you're willing to do at this point?
Not at this point, depends on the court's ruling, of course. I like the invitee designation, Your Honor, of course. And one thing, I just want to make sure she's not cutting across. She's walking along the edge of the floor. Little does she know that corner sticks out.
Oh, so she wasn't crisscrossing it.
No.
That's my understanding. She was crisscrossing it to go to Fossil.
She was headed towards Fossil, that is correct, but not crisscrossing.
She wasn't crossing it across it. She just happened to.
Yeah, the photos will show that the floor
like,
runs pretty straight until the very corner where it sticks out and is raised as well.
Okay, but I go back to she didn't have any intent to stop. How can we overcome the, how do you overcome the invitee designation label?
Being an invitee of La Plaza Mall, for one. For two, as we said earlier, by her browsing, there is a mutual benefit. Does she actually have to stop the kiosk for the La Plaza Beauty to benefit? My answer would be no. They're allowed to browse around. That's why the kiosk is located at the mall. They're hoping customers will be browsing around and stop. Do they have to stop to be invitees? I say no.
And Judge, whether they have to stop or not, I think it's maybe a little, I don't want to say that it's irrelevant at this point, but I would just read the deposition transcript, and so I can read the relevant part. Have you ever shopped or done business with them? Them being my client. She says, no, sir. You've never been to their kiosk before? No. And that day you weren't going there to buy anything. You were going to the fossil store. Yes, sir. I was going to the fossil store. So all the intent points to, I had nothing to do with that kiosk. I was on my way to the fossil store. There was no intent to browse, stop, maybe look at something, maybe change my mind. She was very clear. There's no uncertain terms. I was going to the fossil store. So I don't think that there's a mutual benefit. And again, going back to the discovery responses, she says, I have no evidence to prove that I'm an invitee.
So Mr. Chapa, but anybody who we could argue that browsing is automatically triggers a designation of an invitee, right? Browsing, I can go to Walmart, browse. I don't have to go into Walmart with the intent to buy anything and still be considered an invitee, right?
Correct.
So isn't everybody a potential invitee at a kiosk if you're walking by and you might not be looking for a watch, but I see one and I stop? The fact is that I'm browsing, just walking by it. I don't have to necessarily, I mean, it triggers my intuition or my curiosity. It's almost no different than having a picture of a model showing off a jewelry, showing off a watch, showing off, things of that sort. All those things create my intent to look, to browse. I'm assuming that that's the reason why they wanted to fix up their kiosk, to make it look more attractive to a customer that was walking by. That's why people create track lighting, to create more of an ambiance of lighting, things of that sort. So why not an invitee then?
And Judge, that kind of goes back to the word may. There's a case on here, a visitor to a business establishment who makes a visit only for her own purposes is not an invitee. That's Holder v. Mellon. That's a 1999 case, Judge. So if she's crossing over and happens to trip, I would argue that they're there for their own purposes. And I understand that it's a kiosk, but where they're walking through, they're walking for their own purpose. They're not forced to go. There's a lot of space in between that kiosk and the next kiosk. Those hallways are large for a reason.
It just seems like the other thing that I look at it, and it's like I look at the fact that platform is wider than the actual kiosk, right? Which creates a tripping hazard, because it's not like, even if I was walking parallel to the kiosk, I'm gonna trip over it because it protrudes by, I don't know, just looking at it, it protrudes by a couple of inches. Okay.
One other note, just one last note, please. And that would be that there is a video that shows that, as a matter of fact, the client did browse for additional time. I believe Mr. Chapa knows, he's the one that indicated that to me, that the video shows that she shopped for additional time, at least, I think it was more than 30 minutes, maybe 40.
That's right. That's a video of her browsing for some jewelry at an adjacent kiosk after the alleged injury for about 30
And yet
minutes.
she had no intention to buy jewelry that day. So there you go.
Still be providing a mutual benefit because she's browsing.
But she may end up being your customer along the way.
Yeah, okay. Anything else, Mr. Chapa, Mr. Garza?
No, Your Honor.
All right,
If the court wants to take it under advisement and issue a ruling at a different time, we're trying to currently schedule a mediation for this case. If Mr. Garza can provide me, I guess, with some case law supporting his theory, I'll gladly withdraw the motion, Judge.
I'll do the same, because the two cases that he cites are Kentucky Fried Chicken, where somebody cuts across a parking lot. And the other one he cites is about a girl who gets abducted and taken to a motel parking garage and gets raped there. So those cases are distinguishable, Judge. There is no case law on that. That's all I have here.
okay.
We do have April dates, though, that we proposed for the mediation to both councils.
Okay, let me put you guys in a breakout room real quick. Let me visit with y'all. I will join you in breakout room 2. Okay, I am back. And let's move on. Ms. Martinez, Carla Saenz Martinez, your announcement.
Good morning, Judge. I'm here on CL 203843-H. It's the Josue Oviedo versus the Jacqueline Moreno.
All right.
Stephen Gibson is the plaintiff's attorney. I was hoping he would be here today because I have not received any response from him regarding we've settled one of the claims for the father, the bodily injury claim. There is a pending, there's a offer that was made on behalf of the minor's son. I have not received a response. I've texted him, emailed him, called him, and I just don't get him, I'm afraid, to respond to me, and I was hoping he would be here today.
Go ahead.
I was hoping he would be here today to perhaps we could be sent to a breakout room so that I can finally discuss this case with him.
Give me 1 second. Let me see if my staff has spoken to him. Give me 1 second. All right, Ms. Martinez, we're going to try to locate him and call him on his cell phone to try to have him log on. I think it's a great idea for you to go into a breakout room and see
Thank you,
if
Your Honor.
at least begin the communication.
That would be great. Thank you so much.
You're welcome. All right, Caitlin.
Good morning, Your Honor.
Morning.
I'm here on cause CL2032968, Anita Evangelista versus State Farm. I represent the defendant. And
Morning, Your Honor. David Rohrig here on behalf of plaintiff. This would be my client's motion to compel.
All right, David.
Your Honor, Ms. Logie and I had a chance to speak. I can't remember if it's last week or the week before, and narrowed down our disagreement to one request for production. I've reviewed both their answer and their response to that. It is request for production number 2, whereby we have requested a copy of the claims file. They then responded, and I think their quote of what they say in their response to here's your claim file is real instructive, and I'm going to read it verbatim. Quote, claim file, end quote, has a distinct meaning to State Farm based upon the portion of its claim procedures guide that provides instructions on what to provide from ECS, their electronic storage system, to generate a, quote, claim file, end quote, for production. Here's the part that I find very instructive, Your Honor. For production outside the ECS environment. So basically what they're saying is, but we're only going to take little bits and pieces out of our electronic storage system that has everything we have for your claim and give you just the pieces that our guide says you can have. Now that environment, Your Honor, the only analogy I can think of is imagine if I take my username and my password and log into my Facebook page and I decide, you know what, Judge Maldonado told me I've got to give him my entire Facebook page, but I'm going to give him my profile picture, my date of birth, where I live, and where I was born, and just tell him that's everything he's entitled to of my Facebook page. It doesn't have the time my drunk uncle made the dirty comment on some picture of mine. It doesn't have when I went to spring break. It doesn't have all the other things that I would be able to access on my Facebook page. It just has the 5 things I decided to give you when you told me to give you a copy of it. What I want, Your Honor, and what I'm asking this judge to compel them to give me is access to the system to see everything they can see for that claim. And if not, if they've got certain portions for which they've got a good privilege claim, label those and prevent me from accessing just those. But they shouldn't get to pick and choose the 5 things they give me and just, it's not even 5 things, Your Honor. From their entire spectrum of information or documents that they have in their electronic system, they provided me the declarations page, the author or the authentication page for the declaration page, their property damage photos, the police report, the insurance policy. They give me those 5 things, and I'm supposed to believe that everything else either doesn't exist or is privileged. That's just ridiculous, Your Honor. There's a lot more in that system. We're entitled to know what it is they have to say and what their correspondence has been about this claim in order to determine whether we have a good claim and cause of action for both breach of contract and the declaratory judgment to determine the rights under the UIM policy.
All right, response?
Thank you, Your Honor. Yes, the case law on this issue is clear and explicit, as explained in my briefing thoroughly. There are two cases directly on point. In State Farm, which explains why extra contractual claims are not ripe at this time, and in Progressive, which prohibits discovery of claim file material in UIM cases such as this. I emailed these cases to the court coordinator, Eddie Villanueva. Do you, by chance, have them available?
Give me 1 second.
Thanks.
You emailed them to him directly or through the clerk's office?
To him, and I copied opposing counsel. I wasn't sure how best to provide it. I know in person I would have handed it to you and asked to approach, but
Okay, I have them there. I have them.
you do? Okay. So in response to plaintiff's counsel arguments, we have already produced all relevant and non-privileged portions of the claim file that are at issue in this litigation, and we've produced them in a reasonably usable format, which is all that's required. Plaintiff's request for production number 2, as explained in my response brief to his motion to compel, he did not request the native format or any format beyond what's been produced in his request. So he is asking in his here today in court for documents in a form which he has not even requested in in his request for production number 2. Let's see. Moreover, the case law provided is clear and explicit on that discovery in UIM cases is very limited at this stage. Specifically, plaintiff is only entitled to discovery pertaining to whether or not the plaintiff is legally entitled to recover compensatory damages from an underinsured or underinsured motorist. This is from the Brainerd case. At this point, that has not been established. There has not been a judicial determination of the plaintiff's entitlement to those benefits, at which point, from the Progressive case, if I could direct you to paragraph 13, liability in UIM case, right? Here the court found that liability for the UIM claim has not been judicially determined, which the facts of this case are very similar to the case here today. The court found that the extra contractual claims were not yet ripe and could be rendered moot by the underlying liability determination in the UIM case. That's similar to the situation at hand here in this case, because that determination has not been made, and the court they concluded that abatement of the extra contractual claims is necessary to avoid unnecessary litigation expenses, conserve judicial resources, and to do justice, avoid prejudice, and further convenience.
So are we arguing that it should be abated? Or are we arguing for a discovery issue that, some discovery that Mr. Rohrig should be entitled to some discovery? I mean, those are two totally different arguments, right?
Yes, so he is asking for discovery of a claim file, which the court have long established is not relevant at this point in the litigation because there are not extra contractual causes of action.
So in other words, it's too early for him to be asking for that.
Yes.
All right, Mr. Rohrig?
Your Honor, we haven't filed any extra contractual causes of action. I'm not sure what Ms. Logie's talking about. And the two cases she just put in front of you have been essentially mooted for this question by Allstate v. Irwin. That is 627 Southwest 3rd, 263, rendered by the Texas Supreme Court a full year after both the cases she's talking about. Severing extra contractual causes of action, there are no extra contractual causes of action filed. We filed we filed a breach of contract for the UIM case. We filed a declaratory judgment action asking the court to declare the rights of the parties under that contract to determine what was known when and what information and evaluation was applied to that information by State Farm. I'd like more access than the 5 documents they've produced to me. That is a ridiculous statement that that's all I should be entitled to. Ms.
No,
Logie is right. I didn't ask for native format initially. I thought State Farm might participate in discovery in good faith. They have now not. So now I'd like complete access to the file for this claim number.
Now, I'm assuming that a lot of this is going to be privileged under attorney-client communication or attorney to attorney over the file communication. I'm assuming, right? I mean,
I would have thought that some kind of privilege log might be able to be worked out and documents be produced. Your Honor, the court well knows I spent over 14 years working for insurance companies. I've seen claims files without just these 5 documents. Telling me that that's all there is that I'm entitled to is ridiculous. There's claim notes, there's journal entries, there's emails back and forth between adjusters and management that wouldn't be privileged, or at least large portions of them wouldn't. We have big black Sharpies for redactions. We have privilege logs so that you can identify what document you say is privileged and tell me why, not just tell me I'm going to make that decision. You and the court don't even get to see it, which is what Ms. Logie's trying to tell both of us. She's not giving Your Honor the chance to look at a document, determine whether the claim of privilege is correct or not. She's saying, no, gentlemen, I'll make that decision. You don't get to look at anything but the police report, the pictures, the insurance policy, and the deck page? Really?
all right, Ms. Logie.
Yes, Your Honor, I'd like to respond to that. It seems like opposing counsel has a clear misunderstanding of Allstate v. Irwin. It does not move these cases. It's unrelated. The case law is clear, explicit, and established. There have been mandamus decisions, such as the cases that I cite in Progressive, as you'll see in paragraph 13. They are not entitled to the claim file at all. We have produced the relevant portions that they would be entitled to. This is not an unusual case. These are the things that are produced in these types of cases, because anything else would not be relevant at this time. It's let's see. As stated, they're only entitled to discovery related to liability and damages. These claim file materials are they're privileged, and they're just not relevant at this time until those have been established. There have not been any extra contractual claims established, and even if he were to plead those claims, they would not be ripe, as I explain and cite to the NRA State Farm case that I sent. And so,
Your Honor, the reason that Irwin moots the portions of the 2 cases that Ms. Logie has provided the court is because the sentence right after head note 5 of Irwin, and I'm happy to provide that, 627 Southwest 3rd 263. I can email it to the court. That sentence says the UDGA, the Uniform Declaratory Judgment Act, provides that, quote, a contract may be construed either before or after there has been a breach. In other words, plaintiff, me and my client, are entitled to put evidence in front of Your Honor and have either Your Honor or a jury construe the benefits that should be entitled, i.e. payment of UIM monies, to my client from State Farm. I don't have to establish a judgment first exceeding the underlying policy. I just don't understand how it could be misread. I didn't file extra contractual claims because I read the case law and I know they would be premature at this point. I understand what I'm asking for, Your Honor. I'm asking for a fair look at what's there. And if there are privileged things, I can read the case law. I know what's privileged. I'm happy to submit that to Your Honor in camera, but I'd like, now that State Farm has shown they won't participate in good faith and discovery, the opportunity for Your Honor to determine whether any of their claims are correct. Claims of privilege.
may I respond?
Sure.
Your Honor, as you'll see in the Progressive case that I cited and provided to to the court. This case is very similar to the issue here, where plaintiff's counsel filed a motion to compel various discovery, which included claim file materials, very similar to what's at hand here. As you'll see from this case, any other holding would be an abuse of discretion, not in defense's favor. These are, case law is very, it's clear and explicit that the plaintiff is not able to gain access to claim file materials at this point in the litigation.
But okay, and I can understand that if this was an extra contractual claim, but Mr. Rourke is saying it's not.
And so as of right now, he is only allowed to request documents related to liability and to damages. And we've provided all those documents, the non-privileged portions of the claim file related to damages and liability.
Your Honor, I would agree with Ms. Logie's take on what Progressive says if Progressive didn't come out of the Fourth Court of Appeals, which Irwin specifically told the Fourth Court, the San Antonio Court, you're wrong. You don't know what you're doing with these kinds of cases. This kind of discovery is explicitly allowed in these kinds of cases because the UDGA provides for a court or jury to construe whether there was a breach or not. This portion, the language that Ms. Logie is quoting to the court, has been completely mooted because it's the exact same court that was told it was wrong in a declaratory judgment case for UIM benefits.
Okay, let me take a look at those cases. Mr. Rourke, can you email those to Mr. Villanova? I was able to print out Ms. Logie's cases. Can you send me those, please?
I will, Your Honor, and it's a deeper dive just on the one thing. Progressive, you have to look at it's not Texas Supreme Court, it's the San Antonio Court of Appeals. If you'll look at where Irwin came from, it came from the San Antonio Court of Appeals where they got it wrong. And the Texas Supreme Court said, no, ladies and gentlemen on that bench, you're wrong. This is what's allowed. You can get to this place with a declaratory judgment action on a UIM case. Thence, the discovery would be needed to establish it. I'll get that case to you before lunch, Your Honor. May I send it to Mr. Villanueva the same as Ms. Logie did?
Yes.
Okay.
All right.
Thank you for your time, Your Honor. Maybe excuse.
Submit orders, please, and I'll have a decision here once I read the case. Thank you, guys.
Thank you, Your Honor.
Your Honor.
Thank you. All right, Ms. Martinez, we're still waiting. Let me go back to Mr. Youngs and Mr. Gray.
Yes, good morning, Your Honor.
Yes, CL 214283H, Feliciano Chen versus Connie Cobb, substitute trustee.
Yes, Your Honor. We're still working on settlement. I think we're going to get there. We're just going to get the property inspected, and then we'll most likely be going forward with getting the payoff, the loan paid off, the terms we discussed last time with the unpaid principal balance plus the interest, not the default interest or any of that.
Perfect. What do you think? A status in 60 days?
Sure, we'll have it.
Sure, it may not even be necessary. I think we're going to have everything paid out. The price that we ended up at and that was discussed at the last hearing was $175,288.18. And we'll get the inspection done and and with that, we won't be going forward with a foreclosure on the first if everything goes appropriately.
Okay, so guys, so you do not think a status is necessary? I could just let it sit and.
I think we're fine without it.
Okay, perfect. All right, thank you guys. Thank you all for communicating.
Yes, sir. Chris, I'll be in touch with you.
Thank you, Travis. I'll talk to you. Have a great day, Judge.
Thank you, you too. Okay, any word from Mr. Gibson? Okay, so how about anyone else ready? I have how about Mr. Judge Contreras on the I'm sorry. All right. Mr. Ramos, I see that you're here on a divorce. Can you hear me?
Yes, Your Honor. I apologize. I was on another Zoom.
No problem. F 3794-21-8, in the matter of the marriage of Sergio Garcia Jr. and Alexandra Ramirez. I have a note here was an attorney retained by respondent. Respondent, I'm assuming just from the notes I have here, is your client, correct?
Yes, Your Honor. She retained me, and I reached out to opposing counsel, and we executed a Rule 11, but there was issues with the filing, so we're filing it this morning, Judge, and we're just asking for a little bit more time so I can confirm income information so we can finalize the divorce.
Perfect. So what I'm going to do here is I'm just going to make a note that it was passed by Rule 11, and you all can go ahead and submit a final hearing whenever you all are ready.
Will do, Judge.
All
Thank
right.
you very much.
Thank you.
Have a good one.
You too. Okay, Fabian and Mr. Gomez. Let me see, is Fabian available? Where's Mr. Fabian? Lorena Gonzalez, I see Ms. Gonzalez present. Ms. Gonzalez, are you at Fabian's office by any chance, or are you at?
Yes, I'm at his office.
Okay, is he available? Do you know?
Let me go check.
Perfect, thank you.
He's on his way.
All right, thank you. Yes, Mr. Sanchez.
Good morning.
Good morning, Fabian. Give me, let me start my video. There we go. All right, I have Mr. Gomez, and we are here on a motion to modify temporary orders.
Yes, Your Honor, we filed this motion to modify because as it is, we were unable to settle the case, and this case is going to probably take longer than we expected. I think Mr. Gomez's client wants a jury trial on the issue of custody. And so right now we're under some temporary orders, and basically what we're asking to modify during this interim period is the drop off and pick up of the children. Right now, drop off and pick up is at a location that's kind of far from my client. So we were proposing in our motion to modify a location at midpoint between the residency of my client and Macario Ibanez III's residency, Judge. That's what the motion is addressing. So we would want the court to order that the drop off or pickup be either at the daycare where the children are when it's time to make the change, or at 1009 East Expressway 83 in Donald, Texas, which would be the midpoint between where my client lives and where Macario Ibanez lives.
Okay, I'm assuming that Mr. Ibanez lives in Cameron County?
He lives in Donna, Your Honor.
He lives in Donna.
Donna.
Okay, and where does your client live, Mr. Guerrero?
Alamo, Judge.
Okay, so we're Alamo and Donna are like sister cities.
We're not opposed, Your Honor. We just need to know what the address 1009 West Expressway is.
That's a Stripes convenience store that's located at that point, Mr. Gomez.
Okay, is this the one right there on Hutto?
Is it here? Okay, it's on Hutto.
Yeah, we're fine with that. We're not opposed to that.
Oh, perfect. Then our job here is done. Sorry to keep you guys.
No, he's paying right now. There was one more thing, Judge. He's paying right now $350 a month of temporary child support. We believe that to be a little bit low. We were going to ask for a modification of the amount of child support he should be paying. based on the income that was disclosed at the mediation that was obviously unsuccessful, right? But we would want an increase in child, and it's temporary child support, but we would want an increase of $700 of child support per month.
Okay, so based on his income, I mean, what does his income show the child support to be?
Right now, his income showing what he disclosed to us for previous years, because it was kind of sporadic, Judge. We were looking at it should be $700. He earned on the year that he did disclose $30,000 a year. So $30,000 a year, and he's obliged to support 3 children. So 350 is too low.
Your Honor, we disclosed, 2018, 2019, 2020, 2018, 2019 were, I guess, joint filed income taxes. He was unemployed until he started his own construction company in October. That's, we don't have any, working on the tax stuff for the end of last year for this.
We were forced to rely on what he did disclose, Judge. I mean, obviously, if he was at one point employed at the rate of 30,518 per year, I mean that any lower income would be really at his own volition. It would be more like intentionally underemployment. We've got 3 children here, and we were hoping for an adjustment upward, because 350 is very little money.
Okay, so 350 is somewhere in the neighborhood of minimum wage, correct?
Correct, Judge. That's correct.
Right, and you're saying you have information that would show that child support should be at 700 based on the income that was provided to you.
Yes, Judge.
Okay, so and Mr. Gomez, would you disagree with the numbers that have been provided to Mr. Guerrero that would show that based on those numbers, child support should be at 700? Would you disagree with that? With that math?
Not with that math, Your Honor, no.
Okay. So based on that, obviously there needs to be an upward temporary modification of child support from 350 to 700. I just want the number that is right. I mean, I don't want this to come out of thin air. If it's 656, it's 656.
Judge, and in all fairness, when we go and litigate this thing, if he's been overpaying, he'll get credits towards future child support, right? If he's been underpaying, there'll be an adjustment. So this is just temporary orders, and he's been paying 350. So it's like if he's been underpaying for the last few months, if by some chance he's overpaying a little bit, I mean, I don't think our estimates are unfair.
Well, I want the number to be as close as possible. So whatever the number is, I want it to be as close as possible, and whatever it is, it is. I mean,
and the closest possible number is 700. From our calculations, based on the yearly income.
Okay, the court will go ahead and grant that request and modify it to $700.
Thank you, Judge. We have no other requests other than wait for a jury trial on this.
Does this have a DCC to put you all on the board? Because if not, I need to put you on.
Yes, we could get a DCC.
Yeah,
right,
Your
David?
Honor.
We need a DCC.
Okay. March 1st at 2:30.
March 1st. Thank you,
2:30
Judge.
telephonic DCC. Okay, to put you guys on the board.
Okay, thank you, Judge.
You're welcome. Submit an order. Mr. Guerrero and Mr. Gomez sign off on it. I'm assuming that you're in agreement with the designation of the pickup and drop off, and 700. You didn't disagree, so the court will make that a ruling. I mean, I understand you may not be able to sign off on it as an agreed order, but as long as you agree as to the form, I'll sign off on it.
Thank you, Judge. Will you be excused?
Yes, both of y'all are excused. Okay. Still waiting on a few people. Really need them to be logging on. Ms. Sines, Mr. Gibson hasn't answered us. And I don't want to keep you waiting if you're still there, maybe on another call, maybe working, I'm hoping. This is set for a docket call on the 10th of March, trial on the 14th. This was just a mandatory status. I'm just going to keep those dates and hope that you all continue to communicate and I think you are the only ones set for that week anyway.
That's fine, Your Honor. I want to keep those dates, and what I intend to do is go ahead and file a motion to enforce settlement with regards to the father's claim, since that has been agreed upon. The only pending matter is the minor son and some property damage.
Sounds good. You all are the
Okay.
only trial that's set for that week. Everything else is already settled. So just
Thank
FYI,
you.
you're number one for that week.
Thank you, Your Honor.
You're welcome.
May I be excused?
You're excused. Sorry to keep you.
That's all right. Thank you so
All
much.
We're waiting on Mr. Sanchez. Ms. Garcia, just FYI, we've contacted him, made some contact to try to get him on.
Thank you.
And yes, of course. And then we're also waiting on Judge Contreras. And those are the only two cases I still have left. Carlos, good morning. We are waiting for Judge Contreras to log on. I have a representative here I have Mr. Castillo here for Savannah, and I'm waiting for Judge Contreras. If you can do me the favor and reach out to him. I only have two cases left, so if you don't mind.
Reaching out to Judge Contreras? Okay.
Yes, please.
Yeah.
Mr. Sanchez, Judge will be in a bit.
I did.
Okay, Mr. Sanchez, can you hear me?
I'm here, Your Honor. Yes, sir.
Okay, perfect. Are you ready to have your case with Ms. Garcia heard?
Yes, sir, Your Honor. And forgive the way I'm set up right now. I had federal in Brownsville in person, and I'm on hold on Master Court right now. But
Okay, no problem. F 2628 in the interest of Nicolas Rocha Jr., a child. I have Nicolas Rocha and Christian Alvarado. And I have Ms. Garcia here.
Yes, Your Honor.
All right,
Your Honor, Catherine Garcia here for the Attorney General's office on that case also.
perfect. I have two Ms. Garcias. All right, Attorney Generals. Okay, what do we have here? Ms. Elizabeth Garcia.
Yes, Your Honor, we were here last week on our request for temporary, well, I guess they're emergency temporary orders to return the children to Ms. Alvarado. And
we're gonna get school records to see how how the child was doing, right? And
yes,
we're gonna let the records determine one way or the other whether we were gonna pull the child out of school from Houston, if I'm not mistaken, somewhere in that neighborhood. Okay, and if the child was doing well, I was going to consider leaving the child in the district or there until the end of the school year and not disrupt it, but give maybe mom some extended standard visits or some sort of visits. And if the child was not doing well, then I think I was going to entertain the idea of bringing the child into Hidalgo County and placing the child with mom.
Correct.
Right? Okay, good.
Yes.
All right. I still
Yes.
remember.
Good memory, Your Honor. Good memory. So first, I'd like to, just update the court. We did, once we got your executed order regarding the release of the records and got that to Barbers Hill Independent School District, it was not given to them in time. So they were out Friday afternoon, and then Monday was a holiday. So yesterday late, we did get the records. They worked expeditiously to get these records to us. And I was just now able to send them to Mr. Sanchez. Basically, I didn't see them until this morning myself. So they were emailed to Mr. Sanchez. And I wasn't certain if, Your Honor, you wanted me to send them to you. What I did was I went ahead and color coded, and this is not before the court properly because I haven't submitted it to you, but I'm going to read to you what the records show that Mr. Sanchez is going to have also. So first and foremost, the children were taken without Ms. Alvarado's permission initially she did give the children to Mr. Rocha for the holiday of Christmas break in 2020, and he was supposed to return them 2021 so that they could return to school down here. They were enrolled at the Montessori school down here. It was in January 2021 where he decided that he would keep the children, and that's when he went and enrolled them in Barbers Hill Independent School District. He had them starting, Barbers Hill Independent School District began on January 6, 2021. Nicolas Rocha, who is the oldest one, would have been in preschool. He was not enrolled into Barbers Hill until March 4th. So we had 39 days in his possession before he was enrolled into preschool. That following week, there was spring break. So I went ahead and just so you can see the color coding, the greens are going to represent absences. So he was enrolled for 59 days of those 98 days that he could have technically been enrolled. Of those 59 days, he was absent 19 times. So that's like 40 days total going out of the 98 learning days that was available to him. So 40% attendance. He then began in August of this year. School began on August 18th. From August 18th to the end of the school year,
Judge, can I say something?
You'll have a chance, Mr. Rocha, through your attorney once Mr. Garcia is done.
So there were 80 learning days, Your Honor, from August to December. including the fact that there were 5, 10, 15 vacation days, he was absent 20 times. So he went for a total of 60 academic days. And that's the oldest one. Nathan, who's the youngest one, who's also only just started this year, he's in preschool, enrolled on August 18th, has been absent 26 times. Also, I have the school records that have been provided to Mr. Sanchez. It's showing for the 21-22 school year that, and they're in Spanish, but he is, for the first and second grading periods, he has under language, which was identifying sounds, letters, reading, consonant, vowel, consonant, being able to basically have a mastery of reading at the kindergarten level. He's at level 3 for most of all of his marks, and that's performance is significantly below expected learning standards. For demonstrating phonological sounds in the first grading period, he was at developing towards expected learning standards, and then moved to 3, performance is significantly below expected learning standards. For math, he's hovering, he has a splattering of mastering headed towards and declining to performing significantly below expected learning standards. And what's significant about this, and this is for the kindergarten year, is that he was there for the last part of preschool. And in preschool, it was shown that while he was mastering social and emotional skills, he was performing significantly below expected learning standards for language, communication, alphabets. It was all 3. Everything has been significantly lower. Your Honor, this would have been the time that he would have been here at Horizon Montessori School. This is the time that he would have been with his mom, who, when the records show that he was actually, they were thriving. The oldest one, was thriving here in Horizon Montessori. Your Honor, you asked for evidence that he is not doing well in school, and here is the evidence that based on this, all of his performance is hovering around the significantly below expected learning standards. Unfortunately, I wasn't able to speak with any teachers to see what, if any, interventions Mr. Rocha has taken with this child, but it's clear that he's not attending school. He's not going to school. There's many days, if you look at the pattern, where there are 3-day weekends, 4-day weekends. And that is a detriment to this child who is already struggling. And for that reason, Your Honor, we're asking that the children be immediately returned to Ms. Alvarado. She has a plan to get them enrolled in school. She has a plan to work with them so that this child who should be matriculating to 1st grade can possibly matriculate to 1st grade next year.
Okay, Mr. Sanchez, do you happen to have a response? And it looks like your client would like to say something. I'll allow him to proffer whatever testimony, but through your question and answer.
Mr. Rocha, you heard what Mrs. Garcia is stating regarding the attendance of school of your
Yes,
two
sir.
children.
Yes, sir.
So, what's your response to that, sir?
My response is, first of all, I didn't take them. She unrolled them and let me take them over here so she can get back on her feet, because she was living in an apartment with
That's irrelevant.
Okay.
I don't need to know that.
Okay. Well, when they came over here, they knew no English. Zero English. So I put them in school, and yeah, they're behind. They were behind. They didn't know. They didn't. And the days they missed was because of COVID, and then strep throat too. It wasn't because I didn't want to put them in school. That's not even accurate at all.
So,
and I have all the records for the doctors and everything.
Mr. Rocha, let me stop you, sir. So the court is asked that I ask you questions and that you respond. So I would just ask that only you respond, please. One.
I'm sorry.
And two, just please only answer the questions that I ask. I mean, you're going to want to go on and on. You'll have a chance to say what you need to say.
Yes, sir.
But regarding the medical reasons of what you had, did you present the medical records to the school district?
Yes, sir. And then they have a procedure here that I have to wait. If they have 2 or 3 symptoms, they have to stay home for 2 or 3 days. Was it 3 days or 2?
Yes, they can't go back because of this.
Yeah, because of what?
The 2 symptoms rule.
2 symptoms rule. They can't go back until they have no symptoms. That's the only reason they missed.
Have they ever done any remote learning or any video type of online?
They don't offer it here. They didn't at the beginning of the school year.
Do you happen to have those medical records to show, or did you take them to the doctor and have that?
Yeah, yes, sir. Yes, sir.
I'm gonna ask that you send those over to Mr. Sanchez, please, like today. Okay?
Today?
Yeah, we can get all of them.
Yeah, that's fine.
Okay. All right,
That's-
Mr. Sanchez?
And Mr. Rocha, also, have you ever been in trouble with the district for any sort of truancy or been investigated by the ISD Police Department? Have you ever been called to court or
No, sir.
arrest?
No, sir.
Have the teachers of your children ever contacted you to just say that you're not in compliance and that you're
No.
risking a possible crime, anything like that?
No, sir.
And anybody with the district, anybody with the administration on campus, anything like that?
No.
Your grandfather passed away.
And yeah, and then the other days they miss is because my grandpa passed away. So they missed two days before Christmas break.
How are they on homework assignments and all? Are they up to date in school?
What was that?
How are they up to date with their assignments in class?
Yes, sir. Yes, sir. They are. Yes, sir. They are. It's just taking up some time for my oldest son to now he knows English, or he's speaking fluently. And I mean, because when I got him, he couldn't even say a sentence. He didn't even know his ABCs.
And if the court asked for an update of your teachers, of your 2 children, would you be able to contact those teachers and get some sort of progress report of where they're at as of today?
As of today, yeah, we can do that.
Okay, Judge, I've got no further questions. Of course, open to any discussion.
Mr. Sanchez.
Hold on, Mr. Rocha. Let's listen to the court, please.
Okay, I'm sorry.
All right. I don't have anything else, so I'll allow Mr. Rocha to answer or ask any question.
Yes, sir. Please state what you wanted to say for the court to consider, Mr. Rocha. Anything that I forgot to ask?
Yeah, the English is behind because he had no English skills. It wasn't. And then another thing, what her attorney said, that I took him. I didn't take him. She gave him to me so she can get back on her feet, and I was gonna give him back to her, but then she didn't. The money that she got, she didn't use it for that. So that's why they don't even have a bedroom and stuff like that. And I mean, they have a 2-bedroom apartment, and her brother lives there, his wife, and their 4 kids, and my kids didn't have anything. So here they have their own room. They're progressing. They're in a good school. I mean, what she said is not true. I didn't take them away from her. I didn't just go and take them and nothing. I've even gone out of my way to take them to the valley to see their mom.
Mr. Rocha, will you please work on getting all the documents the court asks and anything else that the judge wants of you?
Can you write it down?
Your Honor, can I ask Mr. Rocha some questions?
Sure.
Yeah.
Let me have Mr. Rocha. I know that I was proffering information from his lawyer, but since you're going to be asking questions, I'm assuming you'd like for him to be under oath. So Mr. Rocha,
Yes, Your Honor.
raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Ms. Garcia, you may proceed.
Yes, Mr. Rocha. You stated earlier that right before Christmas break, your grandmother died. Is that correct?
Grandfather.
My grandpa.
Your grandfather. Correct?
Yes,
Okay.
yes, ma'am.
My apologies. And you also stated that they missed 2 days from school, correct?
I think it was,
No, it was, they left Tuesday. It was Tuesday, Wednesday, Thursday.
yeah,
Friday.
because
They
he
were
was on
half days.
he was on hospice, and I think we left Wednesday.
No, and they were half days. They missed Tuesday, Wednesday, Thursday, Friday, but 2 of the days were half days.
Yeah, two of the days were half days because of Christmas break.
Okay, so they were actually out for those 4 days, correct?
Tuesday through Friday.
Yes.
Okay, and
And then I left for the reason, and then my grandpa passed Friday, so that's why.
And we went to the funeral. And
And yeah, we went to the funeral and came right back.
all right, you also stated earlier, just right before I started speaking with you, that you had an agreement with Ms. Alvarado to return the children to her, correct?
Yes.
their own room.
Yes, ma'am.
Okay. And
I-
has she? Yes, thank you. And has she asked that you return the children to her?
Yes, she
Okay,
did.
it's yes or no, sir. Yes, did she
Um,
ask you to return the children to her?
Yes, but
Okay.
I told her the deal was get them their own room, and then they could go.
And they've never.
So if they have their own room, then you have no problem with the children being with their mother?
I have no problem them seeing their mom and stuff like that, but she doesn't.
Okay.
Her brother and their family lives in the other room.
Right, okay, and that's your thought, is that they live?
No,
in
I
the-
know, because I would go over there. I've seen it.
When is the last time you went to her house?
I couldn't tell you off the top of my head.
But you talked to them and they're all there.
Yeah, and I've talked.
I'm speaking with you and you're under oath. You're the person who's in the room is not under oath, and so I'd ask that you give your responses.
Yes, ma'am.
You've testified that you had an agreement with Ms. Alvarado because she was going to have surgery. You actually had the children for Christmas break from 2020 to 2021, correct?
Yes, the agreement.
And you were supposed to return the children to her in January 2021, correct?
No, you're twisting it. The agreement was for her to she took all the corona relief bills, and I told her, keep the money, get back on your feet, and I'll give you the kids back. And she didn't do that.
She had surgery, correct?
What do you, yeah, she did. Yeah, she has. She had in her chest. Yeah, with the money she was supposed to get her apartment from, so my boys could be comfortable.
She has an apartment in her name.
Yeah, she does, and her brother lives there.
Okay, and she is, and you know that she's employed, correct?
Yeah.
Okay. I'm gonna show you, well, I don't know if I can show you this, but, and I will, what I'm going to do is I'm gonna provide this color-coded calendar to your attorney. And this is my, usually attorneys don't like to share what they're doing, but if you look, and I'm gonna also go ahead and provide this for the judge to see, there is a distinct pattern between both of your children where they're pulled out of school. It's like every Friday, a lot of Fridays. So they have, they're experiencing a lot of 3 and 4 day weekends. And it's a pattern. And now the school reached out to you and told you that, that Nicolas is, may likely be retained for next year, correct?
Yeah, but
Yes.
because of his lack of English, and he didn't get the proper education whenever he was over there. And then if you want to talk to the teacher, he's progressed so much now because
Mr. Rocha, he's done all of kindergarten in Barbers Hill ISD, correct?
Yeah.
And he has not done any kindergarten here with Ms. Alvarado, correct?
Yeah.
Okay, so what extra resources have you provided to Nicolas, who is clearly struggling in kindergarten?
I work one-on-one with him every day when he comes home.
Okay.
On his letters, his ABCs.
Okay, any extra resources other than you working with him one-on-one? Have you provided any additional resources for your child who is?
Yeah, I communicate. I talk to his teacher, and they're putting him in a certain program there, so he can get more one-on-one help.
What is that certain program called?
It's a pull-out program. I don't know the exact name, but it's a pull-out program.
And
they're gonna have more one-on-one time with him.
How many times per week?
Huh? Excuse me?
How many times per week?
2.
2.
I
Okay.
think all week, if I'm not.
Again, Mr. Rocha, these are questions that I'm asking you about your son.
I understand that, but she's, because she communicates.
Again, I'm going to ask her to stop testifying for you on your behalf.
Sir, Mr. Rocha, who is she? Who is that?
She is my fiance.
Okay, so you're not married to her.
No.
Okay, I'm gonna ask her to leave the room. All right, Ms. Garcia, you may continue.
What program has your child been, or what services is your child receiving at Barbers Hill ISD?
He is receiving, I don't know exactly what it's called. It's more one-on-one talk. I mean, more one-on-one time so he can get it faster. So he needs more one-on-one time instead of the whole class, instead of being in the whole class.
When you enrolled him at Barbers Hill ISD, did you know that English was not his first language?
When he didn't even know Spanish either. He didn't know Spanish or English. He couldn't even complete a sentence.
When you enrolled him at Barbers Hill ISD,
yes,
did you know that English was not his first language?
Yes, it was.
Oh, so you told me
it was. His mother talks to him in English. I talk to him in English.
So he did know English when he was enrolled in kindergarten.
Yeah. And then he was so far behind, they had to put him in a program because of whatever they did with his mom. So yes, he was behind, and I'm dealing with the consequences now because of what happened prior.
Did you have possession of your child beginning in December 2020?
Yes.
And you realize that in December 2020, he was theoretically in preschool, correct?
Yes. And then his mom.
Yes or no, sir?
Yes.
Or no?
Yes.
All right. And since December 2020 to where we are today, February 2022, he's only been in kindergarten while under your care, correct?
Only half of it, because she had him in school, and then she unenrolled him so I could take him over here.
Mr. Rocha, you've had your child since December 2020, correct?
Yes.
And you did not enroll him immediately into Barbers Hill. In fact, you waited until right before spring break, March 2021, to enroll him into preschool. And you're claiming and you're representing to this court that you were so concerned about your child struggling, and yet you waited 40 days before enrolling him into preschool, correct?
Yes.
Okay.
I don't know the exact dates, but.
Well, I have the exact dates.
Okay.
And from March to May, the end of May, while he was in your care in preschool, he was absent 19 days. Out of the 59 days you
because of COVID.
So how many times has he had COVID?
He didn't have COVID. He has symptoms, and in school their procedure is that he has to stay home for 3 or 4 days or something like that.
They just all happen to be on Fridays, it appears.
Not necessarily.
Okay, and so did you enroll him in any summer school program?
Yes, ma'am.
Okay, what summer school program did you enroll him in?
The Barbers Hill. At Barbers Hill, I enrolled him in that so he get extra help.
And what days what was the time period that he was enrolled in Barbers Hill summer school program?
I don't know the months off the top of my head.
But you would expect them to be part of the Barbers Hill school records, correct?
What was that?
You would expect them to be part of his school records with Barbers Hill, correct?
Yes.
Okay. And again, he's only been in kindergarten with you, correct?
Yes, ma'am. And he's honestly progressed a lot. A lot.
We already established that you did tell the court that he will likely be retained next year, correct?
No, that's not true. I didn't tell the court that he was going to be detained or he might do kindergarten again. I never said that.
You were told by the school that he is likely going to be retained next year, correct?
No, ma'am. No, ma'am. They talked to me about the difference of why the teacher told me specifically they haven't even gone through that process yet to know if he is or if kids are or aren't. I'm the one that brought it up. I'm the one that brought it up because I was just curious.
You also declined any ESL services for him, correct?
What's that?
You declined any
I didn't
Spanish.
decline anything about school. No, ma'am. I didn't decline nothing for my son in school. I didn't decline anything.
So if there's a record here where you are signing that says that you do not want him enrolled in any ESL programs, you're saying that
No, a new one was sent. That's not true. You should. No, it's not. I can show you proof. I can send it to the court. I didn't deny anything for him. No, ma'am. Why would I deny it?
This is your signature, correct?
It wasn't that. Yes, we signed the wrong form, and then we sent another one to put him in it.
Well, okay.
I promise. Now, why would I deny my son help? And they're both in it, as a matter of fact.
I have no further questions, Your Honor.
All right, Mr. Sanchez, do you have any other questions? Mr. Sanchez, do you have any other questions for your client?
Judge, you see where it says Hugo? And
Judge, I do not. We're just ready for argument. And I'm sorry for the background noise, Judge. I'm on hold on another court.
All right, go ahead. I guess we can have argument.
Mr. Tovar, can you hear me?
I'll allow Ms. Garcia to go first.
Well, if Mr. Sanchez wants to go first, since he's on hold, I would, so that way he can.
Okay, yeah, that works. If that helps you, Mr. Sanchez.
Judge, I would defer to the court, and I would respectfully ask for Ms. Garcia to go first, and she can follow up after I go. But I'm about to get a case reset. Should be a 30-second announcement on the other line.
All right, Ms. Garcia.
Your Honor, we heard from Mr. Rocha himself, who said it was never his intention to keep the children from his mother. We heard from Mr. Rocha, who stated that all my client had to do apparently was get an apartment and get on her feet. There was no questioning of her, but she's here today. She is gainfully employed with Doctors Hospital at Renaissance. She has a 3-bedroom apartment. Her brother does reside with her right now, but she's here and she would testify to the court that they don't need to continue living there. And once her children are returned to her, they would move if that was part of the court's ruling. But Your Honor, what's most important is that, and I will provide this to you, Your Honor, is the color-coded days of absences for just, even if we look just at this academic school year, where they are Friday for a week in September, again in August, it's Wednesday, Thursday, Friday. There's a lot of Fridays. Your Honor, we have also academic records that are showing that the children are at 3, and these are the most current records. Performance is significantly below expected learning standards. When I asked Mr. Rocha about the services provided to the children at the school, he was unable to say what services they provide. He thinks there's going to be a one-on-one with the child.
No,
He's
I
not
know.
certain
I talked to
how
the teacher.
often it's going to happen. He's, and there are programs. There are lots of programs that schools offer. And Ms. Rocha, Ms. Alvarado she knows the importance of kinder and first grade. She knows the importance of education. She never intended for the children to reside with Mr. Rocha. He never intended that. He represented that to the court today. If the only condition apparently was that she get on her feet, she's on her feet. She is representing to the court that she is here. She wants her children back. She wants to enroll them back into school down here. And she wants to make sure that they are receiving the best education. And clearly, there are lots of programs that she's familiar with here that would assist her children. And we're asking that the children be immediately returned to her.
All right. Mr. Rocha, I'll allow you to speak.
When she has a, if she has a 3-bedroom apartment, her brother has a wife and 4 kids.
I'm gonna order, what if I order that they don't live there? Then what?
What do you mean?
Well, I'm gonna order that she reside in the apartment with just her children.
Well, yeah, I mean,
Are you okay with that?
I just want the best for my kids.
Okay, it was a very direct question, because earlier you said that you felt that the reason why you didn't return them was because of the living condition. If I order that no one else lived in the home except for her and her 2 children, are you okay with that? The answer is no, right? Because this is a custody battle, right? So don't make it something it's not, right? Don't make it seem like it's like, okay, well, I'm sorry I said that, but really I don't mean it, because really what I want is my kids, and it's probably an issue of child support, and it's probably an issue of, all these things. It is what it is, Mr. Rocha. Just let's just call a spade, right? Okay, so a very direct question. I probably already know the answer to it, but if I order that she can live in the home, or she's going to live in the home with no other person other than the 2 children and herself, are you okay with that?
No, sir, because
because right now they're living in a home with somebody who's not your wife, and you're okay with that.
I've been with her for 5 years.
Okay,
I have a 3-bedroom house.
You're 5 years and you're not married, right? She's not your wife,
Okay.
and the children are living in that home with her, right? But yet you have a problem with the children living in a home with her brother. I'm saying if I order that the brother, the wife, the kid, anybody other than your 2 children and her live in the apartment, are you okay with it?
Sir, I think they'll be better off with me financially, and
we haven't even gotten into the issue financially. What if she makes more money than you? I mean, we haven't even gotten into
all
that.
due respect, she doesn't, sir, but I'm okay. With all due respect.
Yeah, I mean, what if she does though? Then what?
I mean, I don't understand the question.
Well, I mean, I heard that she worked at DHR. What does she do at DHR, Ms. Garcia?
She does insurance verification. She works in administration, but I do believe Mr. Rocha is unemployed.
Okay, so Mr. Rocha is unemployed and Ms. Alvarado is employed. So arguably she's making more money than you. And I didn't even know this. Okay, now next. Anything else? I mean, Mr. Rocha, you're unemployed, but yet you're saying that she doesn't make as much money as you.
I'm unemployed right now, but I mean, because I got laid off, but I'll be going back to work.
Okay, and again, I'm not trying to demean the fact that we're all going through tough times. We're not. I'm not. That's neither here nor there. I understand. I'm just looking at the situation of what's in the best interest of the children, right? What's in the best interest of the children, period, end of story. I'm not concerned about your feelings. I'm not concerned about her feelings. I'm not concerned. This is where judges are unemotional. I'm not emotional about this. I have nothing. I don't know you. I don't know her.
No,
I've never even met the children. I've never met them. So I'm just trying to figure out what is in the best interest of these children. That is why I said early on a week ago or 2 weeks ago, I said, we're going to determine where these children, if the children are doing well, if they're enrolled in school, they're doing well, they're adjust. I'm not going to move them. I was going to leave them with you. I'm not going to move them, because why would I do that in the middle of the semester? Why would I do that? It doesn't make sense.
Yeah, you're right.
But I did say, I also followed that up with, if they are having trouble, if they're not adjusting, if you're keeping them from school. Look, there's a lot of reasons why you might be keeping them from school. COVID, I understand. The moment you told me that, I get it. I understand. But that only flies a certain, I mean, that's only it can't be every other week. It can't be every week. I mean, and
I understand
it is, even if it is, they're still at a disadvantage for learning. They're still at a disadvantage for learning. And so now I take into account, okay, well, do we have stability? Who do we have more stability with? Do we have, do you have a job? Does your fiance have a job? Or
Yes.
what are we dealing with? I don't know. I don't know. So
Yes, my fiance does have a job.
what I do know is that this will most likely be a custody battle. All right. Both of y'all think that you're the better parent and both of y'all want the children. Right. So ultimately, we're going down the road of a custody battle where we're going to be fighting over custody and who should be the primary, who should have the right to designate the primary residence of the children. Right now, are we there today? No, we're not there today. Are we going to be there next month? No, because I have to order a social study. Someone has to go and investigate you, your fiance, criminal backgrounds, job, living condition, and the same thing for her. Because I'm going to order that if the children are returned back to Ms. Alvarado, that they not live with any person other than her and her children. So they can each have a room so that she can enroll them in school so that we can figure out how well are they doing. But I mean, every concern you've had about why the children shouldn't be with her, we've already addressed it. I think.
I mean,
other than you just feel that they should be with you, right? Just like she feels that they should be with her.
It wasn't like that. I was just trying to help her out. And then once I got them here and then the school and everything, that like it was a good school. They're happy, they have their room over there. They were living, the living conditions weren't good. And that's and then she agreed on it for me. And she unrolled them, she took them out of school and then let me take them. And then and then I told her, take all the corona relief bills, get on your feet, get your place and all that stuff. And then she chose not to do that or whatever. And then the kids seem very, very happy. So it's going to be hard for me. It's not even gonna be, it's going to be hard for them to make that change, because I've asked them, do you want to go with your mom? They don't.
Look here, you want my suggestion, Ms. Garcia?
Yes,
and Mr. Sanchez? And Mr. Sanchez, if you can hear me, this is a great suggestion. I think sometimes as judges, when issues are posed to us, that like, and I'm gonna, the hamster kind of goes off in the head as to how I'm going to solve this solution. Give me a problem, I'll try to find a solution to it. I think I found the solution to it. I got the perfect solution to it. Here's the solution. Between now and spring break, the children will remain with Mr. Rocha in the district. And I'm going to appoint a social study moderator to go to his home at the expenses of both, because this is a child custody, so that they can, he or she, whoever the court appoints, can go to Mr. Rocha and get all the information and witness, get school records, get living conditions, all that between now and spring break. At spring break, we're switching. The children are coming with Miss Alvarado, and they're going to live here with him until the end of the semester. And then we're going to have the social study moderator be able to do the same thing after the children have been enrolled in school. They've adjusted, they're living here, so that we can get a social study moderator that is going to compare apples to apples. Because otherwise, I'm not going to be able to at least have them help me come up with a solution to this problem.
And that includes the living condition over there with her.
Absolutely,
right?
Absolutely. They're gonna go over there for the next couple of weeks. That way, between now and spring break, that buys us about 3 weeks, so that the social study moderator can go up to Houston or your area, wherever you live, and investigate that, do that, go to school, get school records, visit with teachers, visit with counselors. And then the same thing, when the children are here with her, we're going to give the children a couple of weeks, a month or so, maybe like in April, the moderator is going to start doing the same thing here for her. And we're going to have a good assessment, so that, guess what? During the summer, we're having this custody battle. We're going to have this battle during the summer, so that we can, before the school starts again in the fall, we're going to be able to make a better assessment, and I'm going to be able to make the best decision possible. Because right now, I don't have anything other than I feel like the children should be with me. She feels like the children should be with her, and I don't have enough information, but I will. And the spring break is going to be the good break in the week, so that we can take the children and move them back down here, so that
you want them to move schools during spring break.
Correct. So that I can have a good assessment. You have the next 3 weeks to give an assessment to the moderator between now and spring break. After the children are enrolled here, I'm going to ask that they wait a month because it's gonna take a month for
You
the
don't,
teachers.
you don't think that's bad for them to be switching schools and not staying in the same program that they're here?
But Mr. Rocha, she's asking, you're in a legal custody battle right now. And if I don't do it right now, I'm not gonna be able to have a hearing during the summer to determine what's in the best interest of the children before the start of the school year. So I need to make this decision. Otherwise, it's just, well, I have them, so therefore they're gonna stay with me. And why? Because I said so. Well, it's exactly, it is the exact same thing she's doing or asking for. She wants them because she thinks she's the better parent. You want them because you think you're the better parent. And I don't know anything about you two.
Okay. Oh, yes, sir.
I'm just trying, the spring break being a couple weeks away gives us the best opportunity to appoint somebody right now to do that investigation before spring break. They can go, they can check your living conditions, they can check your employment, they can check your fiance's criminal record, your criminal record. I don't know any of those things, right? At the same time, they're going to do the same thing about her. I don't know her criminal record. I don't, right? And but I'm going to order that home be maintained just for the children and for her. That's it. And then a month after they've adjusted to school, because within the first week, no moderator is going to be able to go talk to counselors and teachers and say, how are they adjusting? But a month into it, they will come April, so that we can start having serious conversations about scheduling this in June and into the month of July and August, latter part of July, early August, so that we can make a decision before the start of the school year. Otherwise, I have no information.
And how about if she's moving schools every year, 6 months, because she always moves apartments and stuff like that? Will you take that into consideration?
Absolutely.
Okay. Because
I just need to be able to have somebody go and not search, that's the wrong word. Do a report about the living conditions with you and what I would expect if they lived with you and if the court awarded the children to you. And I need the same thing about her, and the children need to reside with her. It's perfect when they live down the street from each other. It's very difficult when you all live in different area codes. Okay. I think that's a solution to our problem. Because otherwise they should be with me, Judge. They should be with her, Judge. And we're going back and forth and back and forth.
I just feel like my youngest son's gonna have a very hard time.
And maybe he does, but I'm not gonna rip off a Band-Aid because I think it's gonna hurt. I'm gonna rip off the Band-Aid, even if it hurts. And that's just the way we have to approach this. And the spring break gives us that ability to make the break at that point. Mr. Sanchez, what do you think?
Judge, of course, we'll defer to the court. I know you need data in front of you before you make your decision. I would just ask though that all of the medical records and the school records are up to date. I think there's more to the story than just simply missed dates. Maybe some sort of explanation on this, the COVID protocol of the.
Mr. Sanchez, I'm not even considering that, because I'm giving him the benefit of the doubt, because I think we all lived through that. I lived through the fact that before my child was vaccinated, if he had exposure to somebody in his room, they all got sent home. He got sent home various times until he became vaccinated. And then at that point, the protocol was, if he's not showing symptoms, but if he did show symptoms, he had to go home and he had to quarantine for 5 days. Every district is different. I agree with Mr. Rocha. We were all living through, and we still continue to live through, some very interesting and difficult times. I'm not even considering that. I'm simply considering Mr. Rocha wants his kids, Ms. Alvarado wants her kids, and I need to come up with a solution to try to see who's the better fit parent and what's in the best interest of the children. I'm not even considering anything else.
Understood, Your Honor. And of course, we'll comply with the order. My only concern is that just a very rosy picture might be painted on this truncated period between spring break and whichever line in the sand date you draw, that you may see a very rosy picture that might not be 100% reality of the future and the past of these children. So
I'm sure I appreciate you bringing that up and advocating for your client. I'm sure that, you know, you're going to bring that to my attention. And I would expect nothing less from you, because as an advocate, you're doing your job. I think that the spring break gives us an opportunity to at least me visit with the children. I'm sorry, have the moderator visit with the children with mom. And that's all it does. And it gives me some indication, some snapshot of what to expect. Yes, it might be rosy. Yes, she might, fill the room with rose petals and make it smell pretty. I understand that and I get it. But I don't know any other way. I mean, other than to, say, okay, well, because I don't want to change the status quo, then the child resides in Harris County forever. Well, that's not going to happen, because allegations are being brought up that mom wants child. Okay, well, if mom wants a child, then we got to have to do I haven't even appointed an ad litem in this case. And I think that we should. And I talked about that last time, that we were going to need to appoint an ad litem, but we were going to hold off until we had more information. Well, now we're getting into that more information, getting into that issues of we need more. I need more information, and an ad litem is definitely going to help us.
Understood, Your Honor. Of course, we'll comply with that, and I'll work with Ms. Garcia on whatever the court is instructing us to do.
All right, you guys continue to exchange information, discovery, whatever you need. Ms. Garcia, the court's going to go ahead and appoint Cassandra Juarez to do the social study. All right, she has been very good about traveling, has traveled to do other reports. She's very thorough. She is available. We can give you her information so that y'all can reach out, and y'all can do we're going to do a report in Mr. Rocha's home and everything that she needs, and then go and inquire. And so if we need to get her, she'll tell you what she needs, Mr. Sanchez, because we're going to probably need for her to be able to go to the school records, get the school, talk to teachers, talk to counselors, and then include that in her report. At the same time, once the children are returned during the spring break week, they'll remain here. Ms. Garcia, it's your client, Ms. Alvarado, will need to enroll them in school, and then I'm going to give them some time to adjust in school with teachers, and then we'll see how they're doing. And if Mr. Rocha feels like they're not going to adjust well, we're going to know about it. And they're resilient. They're kids. They're in kindergarten. All right. I had a kindergarten kid once. I had two, actually. And when I left school, they were gripping onto my leg like for dear life. And that's what kindergartners do. They cry, they yell, they, want their dad, they want their mom. And then they did okay afterwards. And they're very well adjusted teenagers now. So I'm confident that, yes, we might have a couple of hiccups along the road, but we're going to be able to get through it. And then I want Ms. Juarez to do an evaluation of the children, the home of your client, and visit with teachers, and then give us a complete report. Probably, I'm hoping for mid-June,
Okay.
if possible.
Your Honor, I have the Barbers Hill school calendar up, and I'm not certain about Edinburgh, but I would imagine it's probably the same as McAllen, and the spring breaks do coincide. So, and I know that you're saying the transition needs to be during spring break, but I would hate for them to come on the Sunday of spring break being over, just so that they can have some time to come here right before school starts. Can we get a date?
Yeah, it'll be the Sunday. It'll be the Sunday once school ends. So they'll be with mom for a week. Yeah, I don't know what it is, but it's a Sunday. So school ends on Friday. They're to be returned to mom on that Sunday. Then they'll have the entire week off.
Correct.
No school, right? That's going to give mom a chance to enroll them. That's going to give mom a chance to adjust with the kids. And then the following Monday, they start school again here, whatever district. I mean, I don't know if it's Edinburgh or McAllen, but whatever district.
All right.
And we're going to change. We're going to exchange all that information with Mr. Sanchez so that Mr. Rocha knows what school they're going to, everything. Just the way they have to exchange it with you, you're going to exchange it with them.
Yes, Your Honor.
All right.
Understood.
And then we're gonna
Understood.
wait. And then we're gonna wait, okay? And Ms. Juarez is gonna have to know that we're gonna wait until we give the children time to adjust so that we can get an accurate picture. Because I agree with Mr. Sanchez, it's gonna be a rosy picture of, it's gonna be rosy one way or the, I mean, maybe it's a bad picture, a bad snapshot if we do it right at the beginning. So we're gonna wait. And I think that, you know, probably early May would probably be a good time for Ms. Juarez to go do her, you know, report on Miss Alvarado and the teachers and the kids. And then by latter part of May, we should have a report in. And then I'm gonna appoint, can you guys agree on a ad litem? Because we're gonna need an ad litem on this one as well.
You know, I believe you've appointed Edna Cedillo before, and she did a good job. If Mr. Sanchez is in agreement with her, I have no objection to Edna, or Kathy Alvarado has done a good job before.
All right, Mr. Sanchez, do you have a preference? Either one of those is fine with me.
Are you good
I'll
with
defer to
that?
the court, Judge. They're all solid people. I've known them for years.
Let's do it. Let's have Edna. I think Edna is solid.
Okay.
Okay.
Okay, Your Honor. Do we have another hearing to be set right now?
Sure, I can do that. Why don't we do something? Just gonna do a status.
Yes.
Let's do a status in maybe early April. That's about a couple weeks after the children have been brought over and enrolled here. Just a status. We could do April 13th.
April 13th, Friday?
Is it a Friday?
Yes.
April 13th.
I'm sorry, I'm in May. I'm already at the end of the year. Yes, April 13th, Your Honor. I'm sorry, I have an all-day mediation. Could we do?
Okay. How about the 11th?
I'm good with the 11th, Mr. Sanchez.
Mr. Sanchez, are you good with the 11th of April?
Yes, Your Honor, we'll be ready.
April 11th at 9:30 for a status.
Thank you, Your Honor.
Okay.
And Your Honor, and just real quick for the Attorney General's office, and just to clarify, there's not going to be any rulings on primary custody.
No.
And if and when there are, that's when we want to make sure that there is a medical support order in place and questions as to what sort of medical insurance is available for the children through either mom or dad.
Perfect. Yeah, no, there's no orders at this point.
Okay. Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
All right. Anything else, guys?
Nothing further, Your Honor.
All right. I hope to
Thank you.
get a lot more information.
Thank you, Your Honor.
Thank you. All right. Carlos and Savannah and Judge Contreras.
Good morning, Judge.
Good morning. We have got a status on the Hector Guerra case. It's CL 20-3628H. It's a status conference. I know that we were scheduled for trial. I know that Mr. Contreras and Ms. Gonzalez were going to confer. I know that there were some issues with respect to the remains of Mr. Guerra, and I don't know how or if that was resolved. And then we have the issue of contempt later, but we can deal with those three things. I think that's where Mr. Ortegon comes in.
Yeah, on the, is Ms. Gonzalez available or she's not available?
Mr. Contreras, I'll be standing in for Mr. Gonzalez.
Okay,
Ms.
no problem.
Gonzalez today.
I didn't wanna-
She's actually got called for a bench trial on the 398th.
Yeah, I didn't want to go. I didn't know it was you. Thank you, Mr. Castillo.
Yeah.
Judge, if I may ask, does Mr. Gonzalez have a response? There was supposed to be a response today that she was going to give us.
No,
Do you
no,
have that,
no.
Mr.
What's going to happen, Mr. Ortegon, in the court is that we did provide on the record that the remains are with the mother in her room. I was supposed to send out a letter, Your Honor, but I did do it on the record. If you want, I can send that letter out, Judge, but I think it was sufficient enough to put it on the record last time we were in court, and that was her concern. And we do need some type of hearing, Judge, so we can finalize it. I know we're set for status this morning, and so we just asked for.
Look, I agree. Look, this is the one thing that I know for a fact. The family needs closure. So
yes.
This case needs to be finalized, because whether the remains will be entombed, whether the remains will be divided, whether the remains will be spread out at a something that the family feels is important to the deceased, that they need that, right? And we need to get to that point. And we can only kick this ball down the field so many times, and we then need to get to that point. So listen, guys, this case has been pending since the pandemic almost started, and we need to finalize it. So,
can I just quote real quick? There's one issue that we didn't deal with. We can deal with it the next hearing, and we can expedite it. It's an issue of whether or not a common law marriage existed. There was never a finding by the court. So we would like to present evidence, and likewise, they can present evidence as to whether or not there was a marriage or not. And so we would ask for the hearing to at least have that in mind as well, or that as far as the issue that we need to litigate, so the court can make a finding on that. Aside from the other issues, Judge, I would ask that the next hearing will be also regarding that issue that I just mentioned, Your Honor.
Okay, I think I may have already ruled on that, Judge Contreras, but
No, Judge.
No, Judge, you never made a finding on it, Judge.
Okay.
And Judge, may I add also, I spoke to Ms. Gonzalez. That's why she was gonna have an announcement today on that issue, and Mr. Contreras. So that's why I was wondering if I know that they're standing in for her, but there was supposed to be an announcement today.
An announcement as to what
what they were seeking and were withdrawing.
I remember that, because there was an issue of them wanting to seek some contempt action and monetary damages. And
well, Judge, it was more. I don't want to say what we discussed in respect to Ms. Gonzalez. I know they're standing in for her, but she and maybe another setting, Judge, because that way Mr. Contreras and I and Ms. Gonzalez can discuss, because there was supposed to be a resolution to this case.
Okay, well, let me not get into the way of it. Let you guys figure that out. Is it okay if I reset this for next Wednesday?
Judge, I was going to suggest let's do a status hearing for the sake of Ms. Gonzalez, so she can come in and argue her points.
I would. Yes,
yes, Your Honor. Will be another status hearing. Is that correct, Judge?
Yes, another status hearing, and we could do it next Wednesday.
Yes, Your Honor. Wednesday would be
the second, 3/2 at 9:30.
You don't have anything in the afternoon, Judge, or
let me check.
When? Well, okay, March 2nd. That's what we're looking at. Federal court in the morning or afternoon?
Okay, are you all available? If you want to do it in the afternoon, can we do it at 3?
Yes, Judge. I'm available.
No problem for me, Judge.
Okay. So
yes, Your Honor, and I'm looking at Miss Gonzalez's calendar, and she's available. She'll make herself available.
Okay, perfect. So then next Wednesday at 3, I have some defaults at 2 o'clock, and I should be able to knock those out. Y'all can log on a little early. That would help us in case I knock out those defaults relatively quickly, say 30 minutes, then we can get started at 2:30. But I'm going to set you up at 3, but log on a little early, please.
Yes, Your Honor.
Okay.
Thank you, Judge. Appreciate your time.
Thank you, Judge.
And I apologize for logging in late, Judge. I apologize to the court.
No problem. I had a busy morning anyway.
Yeah. All right.
All right. Thank you, Carlos.
Maybe we be excused, Judge.
Everyone is excused. Thank you.
Thank you, Judge.
All right.
Appreciate it.
That takes care of our docket. Of course, going to log off.